Good afternoon, attorney. Good afternoon, classmates. We are the Group 7, Batalya Irene, Bona Aldrin, Bumakod Daniela, Fernandez Rica May, Makay Jamaica, and Padama Mitch. My name is Daniela and I am the first reporter. So let's go on the first case, the case of Guan versus Commission on Immigration, 15 SCRA 451. Facts of the case. Respondent denied the alleged relationship between Si Guan and said visitors in his response, claiming among other things that the latter had been admitted as temporary visitors and that their right to stay in the Philippines as such had already expired. The lower court issued a preliminary injunction pending a decision on the merits of the case. After hearing the case, the court issued a decision dismissing the petition and dissolving the writ with cause assessed against the petitioners. As a result, the latter has made an appeal. It is undisputed that said visitors arrived in the Philippines on May 21, 1960, and were admitted as temporary visitors for a specified period of time, which upon the request had been extended. Issue of the case. The decision on May 23, 1960 granting Si Guan's petition for naturalization did not impose on respondent the obligation to extend the period of time during which said visitors could stay in the Philippines. When this case was filed on September 14, 1962, Si Guanon stated that the visitors were not Filipinos but aliens. What is more, they still are aliens. For after appropriate proceedings, the Court of First Instance of Manila denied Si Guan's motion to be allowed to take the requisite oath of allegiance and secure the corresponding certificate of naturalization. The following is the language of the order dated July 5, 1963, based on the facts as presented. It is the patent and undeniable that petitioner does. Ruling. Aliens, non-immigrants, power of Immigration Commissioner to extend visitors' stay in the country. It is not the Commissioners of Immigration's ministerial duty to grant a petition for an extension of aliens' stay in the Philippines. As a result, Mandamus will not force him to lie. A writ of certiorari does not suffice because, in the absence of an order by a competent authority which under the Philippine Immigration Act of 1940 is none other than the Commissioner of Immigration, extending the period of a temporary visitor's stay in the Philippines, it becomes the Commissioner's bounden duty to proceed against the temporary visitors and his bond upon the expiration of his right to stay in the country. Wherefore, the decision appealed from should be as it is hereby affirmed, with cause against petitioner appellants, it so ordered. Next case is Ang Leong versus Commissioner of Immigration 510G2893. The facts as gathered from the pleading, stipulation of facts, and documentary evidence filed and submitted by parties. The appellant applied to the appellee for temporary admission into the Philippines of his wife, Ong Shu, and son, Ang Hua, under the provisions of Section 9 Commonwealth Act No. 613 on June 27, 1955, the appellant executed and filed with the Bureau of Immigration cash bonds totaling 14,000 to guarantee the visitors' faithful compliance with the terms and conditions of their temporary stay in the Philippines. On August 1, 1955, the appellant's wife and son arrived in the Philippines from Hong Kong aboard a Philippine airplane. Issue of the case. This is an appeal from a judgment of the Court of First Instance of Manila dismissing the petitioner's complaint which asked for the issuance of a writ of preliminary injunction to enjoin the respondent from forfeiting a cash bond of 10,000 filed by the petitioner for his wife Wong Woon Pon alias Ong Shu and 4,000 for his son Ang Hua, as well as requiring new cash bonds and the same amounts to suspend the enforcement of the respond. Ruling: Aliens Temporary Stay Commissioner of Immigration Authority, Secretary of Foreign Affairs without authority, the entry of aliens into the Philippines is governed by Commonwealth Act Number 613. The Commissioner is the administrative head of the Bureau of Immigration and is in charge of the administration of all laws relating to the immigration of aliens into the Philippines. According to Section 3 of said Act, when the public interest so requires, the President of the Philippines may, under Section 47 of the same Act, admit as non-immigrants aliens not otherwise provided for by this Act who are coming for a temporary period only. Under such conditions as he may prescribe, the Secretary of Foreign Affairs is not authorized to admit aliens for temporary stay or to extend the period authorized by the Act. Power to forfeit bond. The authority conferred upon the Secretary for Foreign Affairs to consider and act upon request for extension beyond the 3-month period from temporary visitors in the Philippines, did not and does not deprive the Commissioner of Immigration of his power to declare a bond forfeited for violation or breach of its term or conditions. The judgment appealed from is affirmed with cause against the appellant. Next is Chang Yu-fa versus Honorable Roberto A. Gianzon. Facts of the case. Petitioners were admitted to the Philippines on prearranged employment as immigrants on November 11, 1949 under Section 13 of the Philippine Immigration Act of 1940, known as Commonwealth Act Number 613, with the express condition that their stay be limited to 2 years. The Immigration Act was amended on June 12, 1950 by Republic Act Number 503, which include amendments such as changing the classification of pre-arranged employees from immigration to non-immigrants. On November 21, 1952, the Secretary of Justice issued an opinion number 314 series of 1952 on proper request, holding in effect that the condition imposed for petitioners' admission to this country, requiring them to stay for no more than 2 years, was valid, implying. Issue of the case. This is a declaratory judgment petition filed in the Court of First Instance of Manila, in which petitioners ask the court to rule on whether the Commissioner of Immigration has the authority to limit their stay in the Philippines as immigrants, and whether opinion number 314 series of 1952 of the Secretary of Justice on the same subject is valid and constitutional. The government argued in its response that petitioners were admitted to the Philippines under Section 13 of Commonwealth Act Number 613 with the express condition that their stay not exceed 2 years, that this condition is not illegal simply because they could have come under Section 13 of said Act. Ruling. The term immigrant usually refers to someone who comes to live permanently in the United States. There is nothing in the law that says it can also refer to someone who comes to live here temporarily or permanently. The only definition of immigrant given by our law is stated in Section 50 of Commonwealth Act Number 613, namely any alien departing from any place outside the Philippines destined for the Philippines. Other than a non-immigrant, the law, on the other hand, gives no definition of non-immigrant. implying that the term immigrant is merely intended to include any alien coming to this country for permanent residence as premises considered. We find no justifiable reason to disturb the decision reached by the lower court, and so we affirm the same, with cause against appellants.
Good afternoon, everyone. I am Jamaica B. Mackay, and my report for today is the Commonwealth Act number 613, Philippine Immigration Act of 1940. In Section 29, the following classes of aliens shall be excluded from entry into the Philippines. Number 1. Idiots or insane peoples and persons who have been insane. Number 2. Persons afflicted with the loathsome of dangerous contagious disease or epilepsy. Number 3. Persons who have been convicted of a crime involving moral turpitude. Next is number 4. Prostitutes or procurers or persons coming from any immoral purposes. Number 5. Persons likely to become public charge. Number 6. Paupers, vagrants, and beggars. Next is number 7. Persons who practice polygamy or who believe in advocate of practice of polygamy. Number 8. Persons who believe in or advocate the overthrow by force and violence of the government of the Philippines or of constituted lawful authority, or who disbelieve in or are opposed to organized government, or who advocate the assault of assassination of public officials because of their office, or who advocate or teach principles, theories, or ideas contrary to the Constitution of the Philippines, or advocate or teach the unlawful destruction of property, or who are members of the affiliated with any organization entertaining or teaching such doctrines. Number 9. Persons over 15 years of age, physically capable of reading, who cannot read printed matter in ordinary use in any language selected by the alien. But this provision shall not be applied to the grandfather, grandmother, father, mother, wife, husband, or child of the Philippine citizen or of an alien lawfully resident in the Philippines. Number 10. Persons who are members of a family accompanying an excluded alien, unless in the opinion of the Commissioner of Immigration, no hardships would result from their admission. Number 11. Persons accompanying an excluded person who is helpless from mental or physical disability or infancy, when the protection or guardianship of such accompanying person or persons is required by the excluded person, as shall be determined by the Commissioner of Immigration. Number 12. Children under 15 years of age accompanied by or not coming to a parent, except that any such children may be admitted in the discretion of the Commissioner of Immigration, if otherwise admissible. Number 13. Stowaways, except that any stowaway may be admitted in the discretion of the Commissioner of the Immigration, if otherwise admissible. Number 14. Persons coming to perform unskilled manual labor in pursuance of a promise or offer of employment, express or implied. But this provision shall not be applied to persons bearing non-quota immigration visas authorized by Section 20 of this Act. Number 15. Persons who within 1 year prior to the date of application for admission have been excluded or deported from the Philippines, but this provision may be waived in the discretion of the Commissioner of Immigration. Number 16. Persons who have been removed from the Philippines at the expense of the government of the Philippines as indigent aliens, under the provision of Section 43 of this Act, and who have not obtained the consent of the Board of Commissioners to apply for readmission. And number 17, persons not properly documented for admission as may be required under the provision of this Act. Letter B. Notwithstanding the provision of this section, the Commissioner of Immigration, in this discretion, may permit to enter any alien properly documented who is subject to exclusion under the section but who is number 1. An alien lawful resident in the Philippines who is returning from a temporary visit abroad. Number 2. An alien applying for temporary admission. Now let's go to Section 30. Section 30. Any alien seeking admission into the Philippines may be required to testify under oath on matters relating to his admissibility. The burden of proof shall be upon such alien to establish that he is not subject to exclusion under any provision of the immigration laws. Next report is Dayata v. De La Cruz, GR number L8775, May 30, 1956. This is an appeal from a judgment of the Court of First Instance of Manila, enjoining the Commissioner of Immigration from causing the arrest of Leoncio Dayata, alias Si Singto, a resident of China, without benefit of bail or bond until the petition for admission as Filipino citizen could be resolved by the Board of a Special Inquiry of the Bureau of Immigration. From the pleadings, stipulation of facts and papers referred to therein, it appears that the said Leoncio Dayata had applied for documentation as a Filipino citizen with the Philippine Consulate in Amoy and later in Hong Kong when the Consulate in Amoy was closed. Favorably recommended by the Philippines Consulate in Hong Kong, the matter was referred by the Department of Foreign Affairs to Bureau of Immigration for comment and recommendation. The Bureau returned the papers on October 27, 1950, stating that it could not make a favorable recommendation in view of inconsistencies between the testimony of the said Dayata and that of his alien mother, but suggesting for further investigation. On March 15, 1954, Trias, the investigators submitted his finding and recommendation, stating that he felt safe to conclude that Leoncio Dayata was in truth an illegitimate issue of Filomena Dayata, a Filipina by her common law husband, Kulu, a Chinese, and was therefore a Filipino citizen and birth, and recommending approval of Dayata's application for documentation as Filipino citizen. On March 22, 1954, the acting First Deputy Commissioner forwarded the record of the investigation of Dayata's application for documentation as Filipino citizen to the Department of Foreign Affairs, and the department in return referred the record to the Department of Justice on March 30. After going over the papers, the Department of Justice on May 14, through the Undersecretary of Justice, gave its opinion disapproving of the findings and recommendation of Trias and declaring in effect that Dayata is an impostor. The opinion says, this department, in opinion number 131 S 1952, and Commissioner of Immigration Diaz in his endorsement of October 27, 1950, ruled that because of glaring inconsistencies in the evidence, ceasing to the applicant cannot be held to be the same person as Leoncio Dayata, illegitimate child of Filomena Dayata. The attempt to explain the inconsistencies strengthened the conviction that the applicant is an impostor. One of the inconsistencies pointed out is that while the applicant testified that his mother Philomena Dayata has gone to China, she and his father Kulu, having accompanied him to China in 1932. Philomena Dayata, on the other hand, said that she did not go with his son on that occasion or any other occasion, for the truth is that she has never left the Philippines. The applicant's alleged father explains that contradiction by saying and his son believed must have been due to the fact that a woman, their neighbor, was with them when they left the Cagayan for Cebu or in their way to China. This explanation is absurd because it is tantamount to saying that an 8-year-old boy, Leoncio was that old, cannot recognize his mother, with whom he had been living since birth. The inconsistencies remain unexplained, and as they are of such a character that they could not occur in the testimonies of persons who are what they really claim to be, this department reiterates its previous ruling and that of Commissioner Diaz denying C's application for documentation as a Filipino citizen. This department does not consider itself bound under the law by the finding of the Board of Special Inquiry that the applicant is a Filipino citizen. Section 27 of the Immigration Act, as amendment, it is believed, give finality to the decision of boards of special inquiry only insofar as they relate to the right of an alien to enter the Philippines, but not insofar as they declared him to be Filipino citizen. Besides, as already noted, Commissioner of Immigration Diaz had previously ruled that the applicant is not a citizen of the Philippines. It is doubtful, moreover, whether the provision was meant to preclude an inquiry into the identity of an alien allowed to land a citizen where, as in the present case, there are grounds to believe that he is an impostor and consequently subject to deportation. Section number 37 of the same act authorized the deportation of an alien who has succeeded in entering the Philippines through false and misleading statements within 5 years after the cause of the deportation arises. Now, it is pointed out, however, that following the submission of the report of the National Bureau of Investigation, Dayata filed his petition for admission as a Filipino citizen, and this seems to be borne out by what appears on page 20 to 25 of the record on appeal. But it does not appear that a board of a special inquiry was formed to inquire the petition of that kind. On the other hand, Trias' report itself says that he treated Dayata's motion for investigation as one of a reconsideration of the previous decision denying the original application of the subject of documentation. And even assuming that Trias also inquired into the question of the appealist's right to the admission to the Philippines, he could not by himself alone render the binding decision of the Board of Special Inquiry because under the Section 27B of the Philippine Immigration Act of 1940 as amendment by Republic Act No. 543 for a decision of the board to be valid and binding, the concurrence of any two of its members is necessary. The action taken by the acting First Deputy Commissioner of Immigration, Francisco de la Rosa, in forwarding the record of the investigation made by the Trias to the Secretary of Foreign Affairs for transmittal to the Philippine Consulate in Hong Kong for whatever action it may deem proper to take the premises, cannot be legally taken as concurrence of De La Rosa's part in Trias' findings and recommendations. First, because the letter of transmittal does not so state, and second, because De La Rosa does not appear to have been designated a member of board of the special inquiry to look into the matter of Dayata's admission into his country. It does not even appear that any such board was appointed, and the statement in De La Rosa's endorsement on page 60 of the record on appeal that the investigation was conducted by the board special inquiry is without factual basis.
Hello classmates, I am Aldrin Bona and I am the reporter of Dolores Neria et al. V. Martiniano P. Vivo G. R number L266611-12 September 9, 1997. Syllabus: Political Law, Immigration Act, Deportation Proceedings, Decision of Board of Special Inquiry, final after 1 year from promulgation. The decision of the Special Board of Inquiry Number 1 to the effect that petitioners are entitled to admission to the Philippines is final after the lapse of 1 year from date of its promulgation. A review made thereafter of the entire proceedings by the new Board of Commissioners of Immigration is null and void for lack of jurisdiction. 2. Issuance of warrants of arrest before final order of deportation is not proper. No warrants of arrest can be issued by immigration authorities before a final order of deportation is made for until it is established that an alien lawfully admitted gain entry into the country through illegal means and his expulsion is finally decreed, his arrest cannot be ordered. 3. Remedial law. Appeals, change of theory, not permissible in appellate court. Instant case. Respondent present instance involves a complete change of theory, which of the course is not permissible. While they went to trial in the lower court below on the theory that the warrant was issued to implement and carry out the decision of the new Board of Commissioners, finding the petitioner to be alien, and that the decision of the new board was valid because it was rendered within year of the promulgation of the decision of the Board of Special Inquiry, which is sought to reserve. It is now the respondent contention that the validity of the new board decision is immaterial because the warrant of arrest was issued not in consequence of the decision but rather of contemplated deportation proceeding against the petitioner under Section 37A 1 and 2 of the Philippine Immigration Law of 1940. Decision: Castro J. The three petitioners, Dolores, Felix, and Manuel, all surnamed Neria, arrived in the Manila from Hong Kong on board a plane of the Cathay Pacific Airways on July 9, 1961. They were followed by the two other petitioners, Simeon and Ramon Neria, who arrived on July 16. The matter of the admission of Dolores, Felix, and Manuel Neria was referred to the Board of Special Inquiry Number 1, which on August 9, 1961, after the investigation, found Dolores Neria to be a Filipino citizen and Felix and Manuel Neria to be her illegitimate minor children by the Chinese national Gan Chongbing, and according vote to admit them. Pursuant to the Section 27B 1 of the Philippines Immigration Act of 1940, the decision admitting Dolores, Felix, and Manuel Neria was forwarded for review to the Board of Immigration Commissioners. The record is not clear whether the decision with respect to Simeon and Ramon was submitted to the Board of Commissioners for review. Although all the identification certificates issued to Felix Manuel Simeon and Ramon Neria on September 1, 1961 explicitly and formally recites that they had been admitted as citizen of the Philippines as per decision of the Board of Special Inquiry Number 1 date August 2, 1961, duly affirmed by the majority member of the Board of Commissioners. On January 24, 1962, the Secretary of Justice issued the following memorandum, it appearing that for the past several years, the Board of Commissioners of Immigration has not met collectively to discuss and deliberate on the case coming before it. Memorandum date January 16, 1962 of the former First Deputy Commissioner of Immigration and the memorandum date January 19, 1962 of the Commissioner of Immigration pursuant to the authority visit in the department head by Section 79C of Act Number 2711 as amended the public interest so requiring it is hereby ordered that all decision purporting to have been rendered by the Board of Commissioners on appeal from or on review motu proprio of decision of the Board of Special Inquiry are set aside. It appears in fact that the Immigration Commissioner did not deliberate as a board but merely acted individually on the case. Those Association Commissioner Talabis and De La Rosa scribble noted on the decision while the Chairman Commissioner Galang wrote exclude. So in August 1962, a new Board of Immigration Commissioner proceeded motu proprio to review the proceeding of the Board of Special Inquiry with respect to the Dolores Felix and Manuel Neria, and finding that they have not satisfactorily established their claim to Philippine citizenship, ordered them excluded as alien not properly documented for admission pursuant to the provision of Section 29A-17 of the Philippines Immigration Act of 1940 as amended and returned to the port they came or to the country of which they are nationals. No review of the Board of Special Inquiry decision admitting the other petitioners, Simeon and Ramon, was conducted, and it is now claimed that none could be made because the record of the case were missing. On July 23, 1965, the Commissioner of Immigration issued a warrant of arrest for the apprehension and eventual deportation of the petitioner. The warrant stating, whereas it has been shown to the undersigned and the undersigned is satisfied that Dolores Neria 51, Pio 22, Felix 15, Manuel 13, Alfonso 27, Victor 26, Juan 16, Simeon 24, and Ramon 17, all surnamed Neria, is a citizen or subject of the Republic of China who is now in the Philippines. Whereas it has also been shown to the undersigned and undersigned is satisfied that the above named alien is subject to deportation under Section 37A1 and 37A2 of the Philippines Immigration Act of 1940 as amended in view of following fact and circumstance: that being Chinese alien not lawfully admissible to the country, on the basis of cablegram bearing the signature of the Secretary of Foreign Affairs Felix Berto M. Serrano by false statement and testimonies. They succeeded in securing documents as Filipino citizens and were able to gain entry into the country of Filipino citizens by means of said fraudulently obtained documentation and by false and misleading statements of misrepresentation, they being aliens, not proper documents for admission. That as to Dolores Neria, she gained entry on the false of fictitious claim that she was born in Makati, Rizal on January 14 or 15, 1914 as the aligned children of Juan Neria and Aladia R. Pedro, and the rest of the above named persons were claimed as the illegitimate children of Dolores Neria by her common law husband Gan Chong Bing, a Chinese who was not married to her, said claim being false. Now therefore, by virtue of the authority visited in the undersigned by law, you are hereby commanded to apprehend the above named alien said to be residing at the wherever found, and to bring him before the undersigned for the said alien to show cause, if any there be, why he should not be deported from the Philippines under the provision of the Philippines Immigration Act of 1940 as amended. The petitioner Neria therefore filed their cases for certiorari and prohibition in the Court of First Instance of Manila. On March 24, 1966, the lower court rendered judgment setting aside the decision of the new Board of Commissioner as well as the warrant of arrest issued by the Immigration Commissioner for lack of jurisdiction and grave abuse of discretion. The court found that the time the new Board of Immigration Commissioner promulgates its decision reversing that of the Board of Special Inquiry, the 1-year period provided in Section 27B of the Philippines Immigration Act of 1940 had expired because while the reversing decision appeared to be dates August 2, 1962, it was in the point of fact promulgates on August 8, 1962, and that the later dates was changed to August 2, 1962 to be make the decision conform to Section 27B. The court likewise held that it was error for the new board to proceed with the review without previously notifying the parties because motu proprio review does not mean ex parte review. The respondent appealed to this court. As we have already stated, these cases were tried in the court on the issue of whether the new Board of Commissioner had the power of review the decision of the Board of Special Inquiry. In the companion case of Pio Neria, Commissioner of Immigration 3, which arose out of the same fact involved in the present case, we found that the decision of the Board of Commissioner reversing that of the Board of Special Inquiry was actually promulgates on August 8, 1962 and not on August 2, 1962 as pretended, and for the reason we held that the said decision of the Board of Immigration Commissioner and the warrants of exclusion issue on the straight of such decision are therefore as correctly found by the lower court, null and void for lack of jurisdiction, since the decision of the Board of Special Inquiry Number 1 by that time had already become final. Consequently, it would seem sufficient to base affirmance of the lower court decision in these cases now before us on the authority of the other Neria case, since all these cases arose out of the same fact and were decided on the same theory. The respondent now claim, however, that the warrant of arrest was issued not in consequence of the decision of the new Board of Immigration Commissioner, but rather on ground warranting the deportation of the petitioner. Otherwise, states the arguments in that the warrant of arrest was issued not under the authority of Section 27B but under Section 37A 1 and 2, 4 of the Philippines Immigration Act of 1940. But there is a more fundamental and insurmountable objection to the respondent's new theory. It is that no warrant of arrest can be issued by immigration authorities before a final order of deportation is made for until it is established that an alien lawful admitted gained entry into the country through illegal means and his expulsion in final decreed. His arrest cannot be ordered. 5. As this court explicitly said in Vivo v. Montesa Supra. 3. The rights of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violent, and no warrant shall be issued but upon probable cause to be determined by the judge of examination under oath of affirmation of the complainants under witness he once produced and particularly described the place to be searched and the person of things to be seized. It will be noted that the power of determining probable cause for warrant of arrest is limited by the Philippines Constitution to judge exclusively, unlike the previous organic law and the Federal Constitution of the United States that left undetermined which public official could determine the existence of probable cause. And in Qua Chigan it Alvi Deporting Board L 20280 promulgates on September 30, 1963, this court point out the exclusive order number 69 of July 29, 1947 issued by President Rojas in the prescribed the procedure for deporting of aliens only required the filing of a bond by an alien under investigation but did not authorize his arrest. The contention of the Solicitor General that the arrest of a foreign is necessary to carry into effect the power of deportation is valid only when, as already stated, there is no already an order of deportation. To carry out the order of deportation, the President obviously has the power to order the arrest of the deportee. But certainly during the investigation, it is not indispensable that the alien be arrested. It is enough, as was true before the executive order of the President Quirino, that a bond be required to ensure the appearance of the alien during the investigation, as were authorized in the executive order of President Rojas. We see no reason why cautionary bound requirements of the 1947 Executive Order Number 69 of the President Rojas should not apply to deportation proceedings initiated by the Immigration Commissioner, considering the identity of ends sought to be served. Such notice and bound should suffice to ensure the subject appearance at the hearings without prejudice to more drastic measures in case of recalcitrant respondent, but as long as the illegal entry or offense of the respondent have not yet been established and their expulsion finally decide upon their arrest upon administrative warrants violates the provision of our Bill of Rights, the constitutional guarantees of individuals' liberty must be liberally considered and applied if we are to enjoy the blessings of the regained of justice, liberty, and the democracy that the Philippines Constitution sought to secure and consolidates. Commonwealth Act No. 613, Philippine Immigration Act of 1940. Deportation of aliens. Section 37A. The following aliens shall be arrested upon the warrant of the Commissioner of Immigration or of any other officer designated by him for the purpose and deported upon the warrants of the Commissioner of Immigration after determination by the Board of Commissioner of the existence of the ground for deporting as charged against the alien. 1. Any alien who entered the Philippines after the effective dates of this act by means of false and misleading statement or without inspection and admission by the immigration authority at a designated port of entry. Any alien who entered the Philippines after the effective dates of this act who was not lawfully admissible at the time of entry. 3. Any alien who, after the effective date of act, is convicted in the Philippines and sentenced for a term of 1 year or more for a crime involving moral turpitude committed within 5 years after his entry to the Philippines, or who at any time after such entry is so convicted and sentenced more than once. Any alien who is convicted and is sentenced for a violation of the law governing prohibited drugs. Any alien who practice prostitution or is an inmate of house of prostitution or in connected with management of a house of prostitution or is a procurer. Any alien who become a public charge within 5 years after entry from causes not affirmatively shown to have arisen subsequent to entry. Any alien who remain in the Philippines in violation of any limitation or condition under which he was admitted as a non-immigrant. Any alien who believes in, advises, advocates, or teaches the overthrow by force and violence of the government of the Philippines or of constituted law and authority, or who disbelieve in or is opposed to organized government, or who advocates or teaches the assaults or assassination of public official because of their office, or who advocates or teaches the unlawful destruction of property or who is a member of affiliate with any organization either trained advocating or teaches such doctrines, or who in any manner whatsoever lends assistance, financial or otherwise, to the dissemination of such doctrines. Deportation may be affected under clauses 2, 7, and 8 of paragraph A of this section at any time after entry, but shall not be affected under any other clause unless the arrest in the deportation proceeding is made within 5 years after the cause for deportation arise. Deportation under clauses 3 and 4 shall not be affected if the court of judge therefore when sentenced the alien shall recommend to the commissioner of immigration that the alien be not deported. No alien shall be deported without being informed of the specific grounds for deportation, nor without being given a hearing under rules of procedure to be prescribed by the Commissioner of Immigration. In any deportation proceeding involving the entry of an alien, the burden of proof shall be upon the alien to show that he entered the Philippines lawfully, and the time, place, and manner of such entry, and for the purpose he shall be entitled to be a statement of the facts in connection with his arrival as shown by any record in the custody of the Bureau of Immigration. Any alien under arrest in deportation proceeding may be released under bond of under such the condition as may be imposed by the Commissioner of Immigration.
Good afternoon, I am Rica May Fernandez and I am going to report the Morano versus Vivo 20 SCRA 562. Facts. Petitioners are Chinese national Chan Su-hua from Fujian with a minor child from prior marriage, Fu Yan-fan, who were granted a temporary visitor's visa as mom immigrant for 2 months upon posting 4,000 pesos cash fund to visit a cousin in the Philippines. She soon married to Stephen Morano, a Filipino citizen, on January 24, 1962 and gave birth to a child, Stephen Morano Jr. After several extensions to prolong a stay in the Philippines, their visas expired on September 10, 1962 and were ordered by Commissioner of Immigration (COI) on August 31, 1962 through a letter to leave the country on or before September 10, 1962 with warning of issuance of warrant of arrest for failure to leave and confiscation of funds. Petitioners then filed with the CFI of Manila of Mandamus to compel COI to cancel their ACR to stop issuing arrest warrant and preliminary injunction from confiscating their bond. They argue that Chan Su-hua became a Filipino citizen upon marriage to Esteban Morano by virtue of Section 15 of Commonwealth Act No. 473 Revised Naturalization Act. Likewise, it argues that Section 37 of the Naturalization Law is unconstitutional for allowing the COI to issue warrant of arrest and effecting deportation without judicial intervention enshrined in the Constitution. CFI decided partly against petitioners, thus COI and petitioners both appealed to SC. Next are the issues. Whether or not the marriage of Chan Su-hua to Esteban Morano makes her a Filipino citizen. Whether or not Section 37 of the Naturalization Law empowering the COI to issue a warrant of arrest and depart upon a warrant on deportation cases is unconstitutional for are covered by the constitutional mandate on searches and seizures without judicial intervention required under the Constitution on searches and seizures. Next, ruling. Marriage to a Filipino citizen does not ipso facto make her a Filipino citizen. She must show that she possesses all the qualifications and none of the disqualification required by the naturalization law, requiring as follows: valid marriage, and alien woman herself may be lawfully naturalized. In the additional stipulation of facts of July 3, 1963, petitioners admit that Chan Sawa is not possessed of all the qualifications required by the naturalization law, thus, she did not become a Filipino citizen. Searches and seizures. Power to deport aliens is an attribute of sovereignty planted on the accepted maxim of international law, that every sovereign nation has the power as inherent the sovereignty and essential to self-preservation to forbid the entrance of foreigner within its dominions. Section 1, Article 3 of the Constitution does not require judicial intervention in the execution of a final order of deportation issued in accordance with law. The constitutional limitation contemplates an order of arrest in the exercise of judicial power as a step preliminary or incidental to prosecution of proceeding for a given offense of administrative action, not as a measure indispensable to carry out a valid decision by a competent official, such as a legal order of deportation issued by the Commissioner of Immigration in pursuance of a valid legislation. Petition for mandamus and prohibition with respect to petitioner Chan Sawa is hereby denied, and judgment declaring her a citizen of the Philippines, directing COI to cancel her alien certificate of registration and other immigration papers, and declaring the preliminary injunction with respect to her permanent are all hereby set aside, and in all other respects the decision appealed is hereby affirmed. And next was the case about Kotek versus Deportation Board L 2384679 SCRA 17, September 9, 1977. Facts. On March 3, 1964, the Chief Prosecutor of the Deportation Board filed a complaint against Kotek, a Chinaman residing in Santa Cruz, Manila. It was alleged in the complaint that in December 1963, certain agents of the NBI searched an office located at 1439 O'Donnell Street, Santa Cruz, Manila, believed to be the headquarters of the guerrilla unit of the Emergency Intelligence Section, Army of the United States, and that among those arrested thereat was Kotek, an alleged section commander and intelligence and record officer of the guerrilla unit. It was further alleged that fake dollar checks were found in Kotek's possession and that, therefore, he had violated Article 168 of the Revised Penal Code and rendered himself an undesirable alien. The prosecutor prayed that after trial the board should recommend to the President of the Philippines the immediate deportation of Kotek as an undesirable alien. Kotek filed a motion to dismiss on the ground that the complaint was premature as he had a pending case in the City Fiscal's Office for violation of Article 168, and that the board has no jurisdiction over the case because the board may only deport aliens on the ground expressly specified by law, citing an obiter in Qua Chigan. The board denied the motion, ruling that a conviction is not required before the state may deport an undesirable alien, and that the board is only a fact-finding body whose function is to make a report and recommendation to the President. It was then that Kotek filed an action for prohibition with the CFI. The CFI granted the petition by upholding the obiter in the Qua Chigan case. It held that Section 37 of the Immigration Law requires conviction of the crime involving moral turpitude, and thus the complaint was premature since mere possession of $4 check is not a ground for deportation under the immigration law. The board appealed the decision to the SC. And next, the issue: whether or not the deportation board can entertain a deportation proceeding based on a ground which is not specified in Section 37 of the immigration law, and although the alien has not yet been convicted of the offense imputed to him. Held, yes, the aforementioned obiter dictum the Qua Chigan case invoked by Kotek and relied upon by the trial court is not of this case. In the Huachigan case, the aliens were with economic sabotage, which is the ground for deportation under Republic Act No. 503, which amended the Philippines Immigration Act. Under existing law, the deportation of the undesirable alien may be effected by order of the President after due investigation pursuant to Section 69 of the Revised Administrative Code, and 2 by the Commissioner of Immigration upon recommendation of the Board of Commissioners of the existence of the ground by deportation as charged against the alien. Under Section 37 of the Immigration Law, when deportation is effected by the President in the exercise of his power, it not be under the ground specified in Section 37 of the Immigration Law, such as requirements, is relevant only when a deportation is effected by the Commissioners of Immigration. Section 69 of the RAC and EO number 398 creating the Deportation Board do not specify the grounds for deportation. There is no legal nor constitutional provision defining the power to deport aliens because the intention of the law is to grant the executive full discretion to determine whether the alien's residence in the country is so undesirable as to affect or injure the security, welfare, or interests of the state. The chief executive is the sole and exclusive judge of the existence of facts, which warrant the deportation of aliens as disclosed in an investigation conducted in accordance with Section 69 of the RAC. After all, the inherent right of the country to expel or deport aliens because their continued presence is detrimental to public welfare is absolute and unqualified, as the precedent is granted in a case. And that's the end of my report. The next reporter will be Mitch Padama.
My name is Mitch. I'm going to report the Commonwealth Act Number 613, Philippine Immigration Act of 1940. Section 37 C and D, Deportation of Aliens. Section 37C, no alien shall be deported without being informed of the specific grounds for the deportation, nor without being given a hearing under rules of procedure to be prescribed by the Commissioner of Immigration. D. In any deportation proceeding involving the entry of the alien, the burden of proof shall be upon the alien to show that he entered the Philippines lawfully, and the time, place, and manner of such entry, and for this purpose he shall be entitled to a statement of the facts in connection with his arrival as shown by any record in the custody of Bureau of Immigration. In the matter of petition for habeas corpus of Andrew Harvey et al. v. Honorable Commissioner Miriam Santiago, GR or General Register Number 82544, June 28, 1988. Facts: American nationals Andrew Harvey and John Sherman, 52 and 72 years respectively, and Adrian van Elshout, 58, a Dutch citizen, are all residing at Pagsanhan, Laguna. Commissioner Miriam Defensor Santiago issued mission orders to the Commission of Immigration and Deportation (CID) to apprehended petitioners at their residences. The operation report read that Andrew Harvey was found together with two young boys. Richard Sherman was found with two naked boys inside his room, while Van den Elshout in the after mission report read that the two children of ages 14 and 16 has been under his care and subjects confirmed being live-in for some time now. Seized during the petitioner's apprehension were rolls of photo negatives and photos of suspected child prostitutes shown in scandalous poses, as well as boys and girls engaged in sex. Posters and other literature advertising the child prostitutes were also found. Petitioners were among the 22 suspected alien pedophiles who were apprehended after 3 months of close surveillance by CID agents in Pagsanhan, Laguna. Only the 3 petitioners have chosen to face deportation. Warrants of arrest were issued by respondents against petitioners for violation of Sections 37, 45, and 46 of the Immigration Act and Section 69 of the Revised Administrative Code. The Board of Special Inquiry Third commenced trial against petitioners. Petitioners filed a petition for bail, which the CID denied. Andrew Harvey filed a manifestation motion stating that he had finally agreed to a self-deportation and praying that he be provisionally released for at least 15 days and placed under the custody of Attorney Asinas before he voluntarily departs the country. However, it appears that on the same date that the aforesaid manifestation motion was filed, Harvey and his co-petitioner had already filed the present petition. Petitioners availed of this petition for a writ of habeas corpus. A return of the writ was filed by the Solicitor General and the court heard the case on oral argument on April 20, 1988. A traverse to the writ was presented by petitioners, to which a reply was filed by the Solicitor General. Issues whether or not the Philippine Immigration Act clothed the Commissioner with any authority to arrest and detain petitioners pending determination of the existence of the probable cause leading to an administrative investigation. Held affirmative, the court rejects petitioners' contentions and uphold the respondents' officials' acts ably defended by the Solicitor General. The petition is dismissed and the writ of habeas corpus is hereby denied. There can be no question that the right against unreasonable searches and seizures guaranteed by the Constitution is available to all persons, including aliens, whether accused of crime or not. One of the constitutional requirements of a valid search warrant or warrant of arrest is that it must be based upon probable cause. In this case, the arrest of petitioners was based on probable cause determined after close surveillance for 3 months, during which period their activities were monitored. The existence of probable cause justified the arrest and the seizure of the photo negatives, photographs, and posters without warrant. The fact that petitioners were not caught in the act does not make their arrest illegal. The deportation charges instituted by Respondents Commissioner and in accordance with Section 37A of the Philippine Immigration Act of 1940. In relation to Section 69 of the Revised Administrative Code, the requirement of probable cause to be determined by a judge does not extend to deportation proceedings. Commonwealth Act No. 613, Philippine Immigration Act of 1940. Section 25. Detention of arriving aliens. Section 25. For the purpose of determining whether aliens arriving in the Philippines belong to any of the classes excluded by the immigration law. The period examining immigration officers may order such aliens detained on board the vessel bringing them or in such other place as the officers may designate. Such detention to be for a sufficient length of the time to enable the officers to determine whether they belong to an excluded class, and the removal to such other place to be at the expense of the vessel bringing them. Section 29A. Excluded classes. Section 29A. The following classes of aliens shall be excluded from entry into the Philippines. 1. Idiots or insane person and persons who have been insane. Second, person afflicted with loathsome or dangerous contagious disease or epilepsy. Third, person who have been convicted of a crime involving moral turpitude. Fourth, prostitutes or procures or person coming of any immoral purposes. 5. person likely to become public charge. 6. Paupers, vagrants, and beggars. 7. Person who practice polygamy or who believe in or advocate the practice of polygamy. 8. Person who believe in or advocate the overthrow by the force and violence of the government of the Philippines or of constituted lawful authority, or who disbelieve in or are opposed to organized government, or who advocate the assault or assassination of public officials because of their office, or who advocates or teach principles, theories, or ideas contrary to the Constitution of the Philippines, or advocate or teach the unlawful destruction of property, or who are members of the affiliated with any organization entertaining or teaching such doctrines. 9. Persons over 15 years of age, physically capable of reading, who cannot read printed matter in ordinary use in any language selected by the alien, but this provision shall not apply to the grandfather, grandmother, father, mother, wife, husband, or child of the Philippine citizen or of an alien lawfully residents in the Philippines. 10. Persons who are members of a family accompanying an excluded alien, unless, in the opinion of the Commissioner of Immigration, no hardship would result from their admission. 11. Persons accompanying an excluded person who is helpless from mental or physical disability or infancy, when the protection or guardianship of such accompanying person or persons is required by the excluded person, as shall determined by the Commissioner of Immigration. Children under 15 years of age unaccompanied by or not coming to a parent, except that any such children may be admitted in the discretion of the Commissioner of Immigration if otherwise admissible. 13. Stowaways, except that any stowaway may be admitted in the discretion of the Commissioner of Immigration if otherwise admissible. 14. Persons coming to perform unskilled manual labor in pursuance of a promise or offer of employment, express or implied, but this provision shall not apply to persons bearing non-quota immigration visas authorized by Section 20 of this Act. 15. Persons who within 1 year prior to the date of application for admission have been excluded or deported from the Philippines, but this provision may be waived in the discretion of the Commissioner of Immigration. 16. Persons who have been removed from the Philippines at the expense of the government of the Philippines as indigent aliens under the provision of Section 43 of this Act, and who have not obtained the consent of the Board of Commissioners to apply for readmission, and 17. Persons not properly documented for admission as may be required under the provision of this Act. Section 22A. Reentry Permits. Section 22. Any lawful resident alien about to depart temporarily from the Philippines who desires a reentry permit may apply to the Commissioner of Immigration for such permit. If the Commissioner finds that the applicant has been lawfully admitted into the Philippines for permanent resident, he shall issue the permit, which shall be valid for the period not exceeding 1 year. Except that upon application for extension and good cause, therefore, being shown by the applicant, it may be extended by the Commissioner for additional periods not exceeding 1 year each. The Commissioner shall prescribe the form of permit, application for the issuance or extension of permits shall be made under oath and in such form and manners as the Commissioner shall by regulation prescribe. Section 45G. Penal Provisions. Section 45. Any individual who attempts or conspires with other to commit any of the foregoing acts shall be guilty of an offense, and upon conviction thereof shall be fined not more than 1,000 pesos or imprisoned for not more than 2 years or both.
Good day everyone. My name is Irene Batalya and I am the last reporter from this group. So my first topic is all about the Letter of Instruction number 5 as amended by DOJ Circular number 17, March 1998 on whole departure guidelines. So what do we mean by whole departure order? A whole departure order, or HDO, prevents an individual to depart from the Philippines. What are the grounds for the issuance of whole departure order? An HDO shall be implemented by the Commissioner under any of these circumstances. First, when the HDO was issued by the Regional Trial Court against an accused in the criminal case which is within its exclusive jurisdiction in accordance with Circular 39-97 of the Office of the Court Administrator dated June 19, 1997. Second, when the HDO was issued upon the order or instruction of the President of the Philippines in the interest of national security, public safety, or public health as may be provided by law. And lastly, when the HDO was issued by the Secretary of Justice upon application of an interested party. So, to whom the grounds of a whole departure order are applicable? Number 1. An accused person who is released on bail. The application shall be accompanied by a certified true copy of the order releasing the person on bail and a certification issued by the clerk of court concerned that the criminal case where the bail was issued is pending. Number 2. A fugitive from justice. The application shall be accompanied by a certified true copy of the criminal information and warrant or order of arrest against the fugitive and a certification issued by the clerk of court concerned that the warrant or order of arrest was returned unserved by the peace officer to whom the same was delivered for service. Third, an alien who is the accused in a criminal case that is pending trial before a court. The application shall be accompanied by a certification issued by the court concerned on the pendency of the trial of the criminal case involving the alien and by a certified true copy of the information filed in the case. Fourth, an alien who is the respondent in the deportation complaint before the Bureau of Violation of Immigration Laws, Rules and Regulations upon recommendation of the Board of Special Inquiry or of the Board of Commissioners. The application shall be accompanied by a copy of the deportation complaint. And lastly, an alien whose presence is required as witness in a criminal case or as the defendant or respondent or witness in a civil, labor, or other case before judicial, quasi-judicial, or administrative body of the government. The application shall be accompanied by a certified true copy of the subpoena or summons issued to the alien and by a copy of a criminal information or of the complaint in the civil, labor, or administrative case wherein the alien's presence is required. My last topic is all about the Republic Act No. 9225 or the Dual Citizenship Law. So let us elaborate what is Republic Act No. 9225. So the Republic Act 9225, otherwise known as the Citizenship Retention and Reacquisition Act of 2003, more popularly known as the Dual Citizenship Law, enables former natural-born Filipinos who have become naturalized citizens of another country to retain or reacquire their Philippine citizenship by taking an oath of allegiance to the Republic of the Philippines before a Philippine consular office. Upon retaining or reacquiring their Philippine citizenship, they shall enjoy full civil, economic, and political rights as Filipinos. Section 2 under this Republic Act is the Declaration of Policy, which states that it is hereby declared the policy of the state that all Philippine citizens of another country shall be deemed not to have lost their Philippine citizenship under the conditions of this act. The Section 3, or the retention of Philippine citizenship under this Republic Act, states that any provision of law to the contrary, notwithstanding natural-born citizenship by reason of their naturalization as citizens of a foreign country are hereby deemed to have reacquired Philippine citizenship upon taking the following oath of allegiance to the Republic. So let me read to you the oath. I state your name, solemnly swear or affirm that I will support and defend the Constitution of the Republic of the Philippines and obey the laws and legal orders promulgated by the duly constituted authorities of the Philippines, and I hereby declare that I recognize and accept the supreme authority of the Philippines and will maintain true faith and allegiance thereto, and that I impose this obligation upon myself voluntarily without mental reservation or purpose of evasion. So that's the oath. Natural-born citizens of the Philippines who, after the effectivity of this act, become citizens of a foreign country shall retain their Philippine citizenship upon taking the aforesaid oath. Section 4 under this Republic Act 9225, the derivative citizenship states that the unmarried child, whether legitimate, illegitimate, or adopted, below 18 years of age, of those who reacquire Philippine citizenship upon effectivity of this act, shall be deemed citizenship of the Philippines. And lastly, the Section 5 under this act, the civil and political rights and liabilities, states that those who retain or reacquire Philippine citizenship under this act shall enjoy full civil and political rights and be subject to all attendant liabilities and responsibilities under existing laws of the Philippines and the following conditions. First, those intending to exercise their right of suffrage must meet the requirements under Section 1, Article 5 of the Constitution, Republic Act No. 9189, otherwise known as the Overseas Absentee Voting Act of 2003, and other existing laws. Number 2, those seeking elective public in the Philippines shall meet the qualification for holding such public office as required by the Constitution and existing laws, and at the time of filing of the certificate of candidacy, make a personal and sworn renunciation of any and all foreign citizenship before any public officer authorized to administer an oath. Number 3, those appointed to any public office shall subscribe and swear to an oath of allegiance to the Republic of the Philippines and its duly constituted authorities prior to their assumption of office, provided that they renounce their oath of allegiance to the country where they took that oath. Number 4, those intending to practice their profession in the Philippines shall apply with the proper authority for a license or permit to engage in such practice. And lastly, that right to vote or be elected or appointed to any public office in the Philippines cannot be exercised by or extended to those who are candidates for or are occupying any public office in the country of which they are naturalized citizens and or are in active service as commissioned or non-commissioned officers in the armed forces of the country which they are naturalized citizens. So that ends our report. Thank you so much everyone for listening. Stay safe and God bless.